Welcome everyone to today's webcast. We're going to be talking about techniques for conducting workplace investigations in sexual harassment cases. My name's Alana Rafter. I'm a Senior Associate at Australian Business Lawyers and Advisors. With me today is one of ABLA's awesome directors, Julian Arndt.
Hello everyone.
And Julian, let's not waste time. Tell everyone what they're going to get out of today.
Yeah, let's go straight into it. So we are talking about investigations into sexual harassment broadly, why conduct investigations at all, and then let's talk about why we're particularly talking about sexual harassment investigations. So sexual harassment and the positive duty. We're going to talk about considerations before investigating, talking about how to investigate with a particular focus on sexual harassment investigations, the report reaching conclusions. We've got a number of great questions already, which is really helpful, and a lot of engaged participants out there. Please, if you have any more questions or things pop up during the presentation, just send it to the device. So use the format, use the forum that you have in front of you as you're watching online, and it'll be a great show. I say we get into it.
So obvious, logical starting point. Why should we conduct investigations, Julian?
Investigations are the bread and butter of HR life, really. Anyone in the HR field, IR field, I guess, tangentially. I mean, workplace investigations are a fact of life for everyone. Often it's lost, the point of investigation. We're just doing investigations because you need an investigation. Someone says there's got to be an investigation into this. The point of investigations is to determine what happened. It doesn't matter what the investigation is, it's always to determine what happened, to find fact. But once you find that fact, there are a whole range of benefits of finding that fact. You can resolve a workplace conflict. Two people are fighting. You find out what happened and then you can resolve it. You can give respect to someone who has a problem, someone who has a complaint, by listening to them, actually dealing with it and giving them a judgment, either yes or no. You can get confidence in yourself as an employer because your employees realise and sort of understand that you're going to take things seriously. Things aren't going to be covered up. Things aren't going to be stitched up. Your voice will be heard. On the other side of all of that, if there are allegations against you as a respondent, you conduct investigations so that that person has a chance to say their piece about the allegations against them, maybe a chance to clear their name, at least their chance to give their side of the story. If you do take disciplinary action against that person and they sue you, maybe an unfair dismissal, maybe a general protectionist claim, something like that, if you haven't done an investigation, if you haven't found out what happened, it's going to be very difficult to defend those cases. And that's what we're talking about when we talk about the last point on that slide. Costly litigation is always easier, it's always cheaper if you've undertook some kind of justifiable investigation process. The technical term that we put at the bottom of that slide is the legal stuff. Investigations are useful for dealing with that, and as two lawyers who have to see the broken pieces of a particular relationship broken down in an unfair or an adverse action claim or whatever it is, our jobs are made a lot easier if a proper procedure was undertaken, and our clients' results are a lot better if the workplace investigation can be done appropriately before everything falls apart.
And that, I guess, is covered in a lot of these generic reasons to investigate that we can see there on the slide there. These are the most common reasons why you'll find yourself conducting an investigation, whether it be to look into an allegation of misconduct or serious misconduct, breaches of the policies or procedures, safety incidents, and of course, complaints of bullying, discrimination.
Exactly, Alana. All of these are categories of the overarching thing of what happened. Was there serious misconduct? Was there a breach of policy? Was there a safety incident or a near miss? Was there bullying, harassment, and so forth? So they're all versions on a theme. All investigations fall basically into these four groups. There's some weird things that go on in very highly regulated jurisdictions and industries where you have to undertake investigations because the department or the regulator says you do. But leaving that aside, this is basically why you would conduct an investigation. I'd be very confident that a very high percentage of our viewers right now know this already and probably have heard it before, perhaps even from me.
Now we come to the positive duty. Sexual harassment and the positive duty. Why?
There is a real important reason why we are fusing these two topics together. There is a very important reason why sexual harassment is a standalone investigation webcast, which we're doing right now, because something very big has happened in this space. Alana, can you talk us through it?
And that is, of course, the new positive duty. We can still call it new positive duty, even though it's been around now for a couple of years, because the regulator in this space only got its enforcement powers as of December last year. So that's why there's a lot of attention on this new duty, which requires all employers to take reasonable and proportionate steps to eliminate sexual harassment as far as possible. This requires everyone to take not only steps to respond to the risk, but to prevent the risk. And as you'll see there, it doesn't just cover sexual harassment. There are 5 categories of unlawful behaviour that this positive duty applies to. Sex discrimination, sex-based harassment, conduct that creates a hostile work environment on the grounds of sex, and victimisation under the Sex Discrimination Act.
And we'll talk about each of those categories. I mean, I feel like I've been talking very loudly about this topic for a very long time, and it bears repeating. This is a focus of the Parliament. This is a new thing, and it is a different thing. The positive duty means that every employer in Australia needs to be taking reasonable and proportionate steps to prevent these specific forms of misconduct, bad behaviour, unsafe scenarios, and so forth. The Parliament could have picked anything. They could have picked racial abuse. They could have picked religious discrimination. They could have focused on anything. They are focusing on this, and they have placed a requirement on all employers to do something about it. This applies whether you have a problem, whether you have a complaint, whether you have a workplace culture that has sexual harassment involved in it. It applies to everyone. You don't need a complaint. You don't need a problem. Everyone needs to be taking reasonable and proportionate steps to prevent these things, regardless of their past history. So if anyone is still out there watching this webinar and thinking, well, we're fine here, we've got a good group here, we don't have this problem, and the risk is, I don't need to do anything. I don't need a policy, or I don't need to review our risk register, or I don't need to have a grievance policy, or I don't really need to have any training for any of our board or employees or managers about the positive duty and about their obligations to prevent sexual harassment. I would please encourage you to get online, have a look at the material on this, because ultimately you do have that obligation. There are things to do in relation to the positive duty for everyone, and it will continue to be a focus because that's what the government has decided.
And one of them is, of course, looking at the way you conduct investigations into these unlawful behaviours, and that's why we'll focus on sexual harassment today. But with this new duty, Jules, does this mean everyone can just forget about other laws? Is this replacing duties, liabilities?
It's a good question. I mean, part of the response that people give to the positive duty, and someone like me talking very quickly and frantically about it, is they say, well, it was never lawful to sexually harass someone, and we always had obligations to prevent sexual harassment. That is true. This doesn't replace any of those obligations, and as you can probably take us through on the slide, there are various existing duties that you have as an employer to keep your staff safe.
In the fair work space, in discrimination law would be, everyone on the line is probably very familiar with vicarious liability. Employers are not liable if they've taken all reasonable steps to prevent the conduct, and that does require you to show you're taking all those reasonable steps. And then, of course, in the primary duty of care in the WHS space, you already have a proactive duty to eliminate or minimise risks to health and safety of workers and others so far as reasonably practicable. And that, of course, includes risks to psychological health, which includes sexual harassment.
Yeah, and they're really generic. They're generic obligations. The positive duty comes over the top of them. It's a rinse over the top of all that, but it's specifically targeted for sexual harassment, sex discrimination, hostile workplace environments, victimisations, and so forth. So things need to be done specifically for sexual harassment reporting and risks, which is why we are here specifically talking about investigations for sexual harassment.
So let's go to what is sexual harassment. We have the elements there on the slide for you. So let's start with unwelcome conduct, Jules.
It's a three-parter. Look, unwelcome conduct is entirely up to the person who the behaviour is visited upon. It is entirely up to the harassed to decide whether it's unwelcome or not. So if you're thinking about that from a person-and-person interaction, only one person is determining whether it's unwelcome, and it's entirely up to them. The second part is conduct of a sexual nature. Sexual advances or other conduct of a sexual nature, which seems a very broad category, Alana. Is it broad?
And indeed, it is very broad. This is covering everything from, I think what's on the slide there is quite helpful, though, from a mere touch, joke, leering, intimidation. It's not just all physical conduct, and that's where some people might start to box it in as just sexual conduct that's verging on more serious, such as sexual assault even.
So I want to make 2 points on this. So when we train boards, businesses, managers and so forth in the positive duty, inevitably when we ask the question, what's the most common reported form of sexual harassment? Everyone says inappropriate touching. That's comparatively rare. What's much more common is intrusive personal questions, unasked for and unwelcome compliments and comments. Sexual harassment is far broader than the very, very serious physical conduct type allegations and conduct that physical contact conduct, which generally people associate with sexual harassment. And I have to say, just as a bit of a disclaimer, and it's important when you're doing a presentation like this, we are talking about workplace sexual harassment. This presentation is not talking about behaviour of such a seriousness that it gets to a level of criminality. And we're not talking about conducting sexual investigations into sexual assault and so forth. It's a police matter, and those things should be reported to police. We are talking about a whole broader range of conduct which often involves words, often involves looks, often involves emails, texts, WhatsApp messages, as opposed to physical touching. How you work out whether it's sexual harassment almost always falls into the last point, the last limb of the test. And that test is, would a reasonable person, having regard to the circumstances, have anticipated the possibility that the conduct would offend, humiliate or intimidate the other person? What do you say to that?
And this is the element of the test that we always emphasise when we're training clients, because what I hope everyone's picking up on is this is a low bar, a low threshold. We're not talking about the balance of probabilities beyond reasonable doubt. We're talking about a reasonable person who would have anticipated the mere possibility that this conduct would offend, humiliate or intimidate. So we're in the realm of possibility.
Think about the reasonable person as a reasonable person in 2024. This is quite an informed person. This is a person who has quite high expectations of people's personal conduct, about people's sensitivities to certain comments about their appearance or otherwise. Occasionally you'll hear from people, well, the reasonable person test in sexual harassment is the pub test. Would a person at the pub think it's inappropriate or over the line, or would a person in the pub think it's going to offend, humiliate or intimidate? I actually think that's a very unhelpful comparison, because the person in the pub is a pretty robust, often bloke in the pub or otherwise. That's the wrong way to look at this. I look at this as what would be expected in a professional context. What would someone educated on the way you're supposed to speak to people, what would someone educated in the way that basically who has the type of person who isn't going to say, well, back in my day, you could give compliments to people in the workplace about what they're doing. It's not that person.
So it's an informed, reasonable person.
Exactly. It's an informed person with modern views. And this gets us to one of the side notes on that slide. The alleged harasser's motivation or intentions are irrelevant. So it actually doesn't matter if the person meant well. It doesn't matter if they thought they were being nice. It doesn't matter if they thought, well, that's how I was treated, or that's how I've always spoken to people in my workplace. Irrelevant.
Or even if they thought it was welcome at the time.
Correct. Was it unwelcome? Not up to them. Was it of a sexual nature? Not up to them. And would a reasonable person looking at the whole thing have anticipated the possibility that someone be offended, humiliated or intimidated? Very low bar.
And not from their perspective.
Correct.
But we should go on to a couple of the other new unlawful behaviours. So here we have sex-based harassment, very similar elements, if I can speak, to sexual harassment. But the key difference is the nature of that conduct. It's of a demeaning nature because of a person's sex. So to put it very simply, it can be described as sexism in the workplace.
It's the shorthand. It's sexism. There's a massive overlap between all of these various forms of unlawful behaviour. So often sex-based harassment will be sexual harassment, and the other forms which we'll go on to. Let's not labour the point, but it is important to realise that, you know, sexism is actually unlawful in Australian workplaces because that's what it is, sex-based harassment.
And then the other unlawful category, Jules, do you want to tell us about hostile workplace environments?
Yes, so the hostile workplace environment is, the classic example is the mechanics workshop with various posters, calendars on the walls of scantily clad people on them. It's not behaviour directed as a person, but it is a environment whereby someone of a particular sex, it's hostile to them on the basis of their sex.
So I could be walking into the office and looking at potentially displays around the office, people's desktop, conversations, things of this ilk?
Correct. In this example, and I'll pick it up because you've raised it, in this example, the comments or the photos or the pictures may not be being sent to you, or comments might not be being made to you, but you have to be in the environment. And if it's unwelcome, and if a reasonable person would think it's has the possibility, anticipate the possibility that it's going to offend or humiliate, you've got this hostile workplace environment. Huge overlap between that and sexual harassment, obviously, but again, it's filling gaps, it's making sure that the relevant legislative standard is covering off on all bases. And just, a quick editorial comment. Yes, there are a lot of laws in this, and yes, it does seem like there is, a high amount of regulation in this space. What we're talking about is having a workplace free of sexual harassment. And I don't know about you, I'm not of a intention, or I've got no interest in defending sexual harassment. I don't think anyone should. This is not asking a lot of employers, and I think any employee who, and we do training, and occasionally you get employees who sit with their arms crossed and think this is PC gone mad, or this is all wokeism, or whatever it is. It's not. It's having a respectful workplace where everyone, regardless of their sex, can just get on with their business and do their job in a safe way. I'm finished that rant, so let's move on.
Respect and safety. So
exactly.
We'll move on from sex-based harassment and hostile workplace environments. We talked about that just to make clear that the positive duty is not limited to sexual harassment, but now we're just going to focus on sexual harassment.
Yep.
But of course, we'll just quickly go through the enforcement powers of the new regulator in this space. So the regulator I'm talking about is the Australian Human Rights Commission. And key thing to note now is we have two regulators in this space that have enforcement powers. So Australian Human Rights Commission can come in to enforce compliance by a variety of ways. They can provide recommendations to employers to achieve compliance. They can issue and enforce compliance notices, and they can enter into enforceable undertakings with employers. So very similar to the types of enforcement powers that your state-based regulators already have as well.
Yeah, and look, as I said, it's part of the agenda to get a robust compliance space in this area. The regulators will be making examples of people. The regulators will be knocking on doors. One of the questions that they will have is, what do you do in relation to investigations? And we'll get to investigations shortly. But yes, this is a space that has a regulator with enforcement powers. So it's a space where your compliance matters.
And that same question about what have you done in this space, that have you investigated, that's a key question they're going to ask before the Fair Work Commission as well.
It is, because the Fair Work Commission now has a power to make stop sexual harassment orders, really similar to the bullying jurisdiction, which some of the people on the line may have heard about or been involved with. Essentially, the Fair Work Commission has power to deal with sexual harassment complaints and make orders. The first thing the first thing that the Commission will ask is, well, have you investigated this complaint? What did you do? How did you go about it? It's also possible that if you investigate it properly, maybe it never gets to the Fair Work Commission and maybe it's resolved. So stay out of the Fair Work Commission in terms of this jurisdiction would be my message. But we're getting very, very close to actually talking about investigations of sexual harassment matters.
One more slide, we promise.
Of course, you have to have the work health and safety, one of your pet projects.
Any excuse, I have to talk about psychosocial hazards. So sexual harassment is, of course, one of the most common psychosocial hazards. So the safety regulator is going to expect to see your psychosocial risk management in this space as well. So that's where we're seeing that overlap. You're going to be having risk management with respect to sexual harassment in terms of the positive duty, but also in terms of your risk management to comply with that proactive duty under the WHS Act. So the documents you're compiling for compliance with positive duty will have some relevance to your compliance with the WHS duties as well.
Let's bring it together. We've talked about why sexual harassment needs your focus. It needs your focus. It is important. It is the time to get this sorted. Well, how do you get it sorted from an investigations point of view? Now, we return to the next slide. We've seen this before,
yes,
but it still applies. Why would you conduct an investigation into sexual harassment? Well, again, it's just to determine what happened. But as you'll see flowing down that slide, all of those things, when you plug it into the sexual harassment complaint or report framework, start to realise how important these things, respect to the complainant, and I use that word with asterisks, italics, underline, respect to the complainant, it's fundamental in sexual harassment matters. Alana, you want to talk a bit about my use of the word complainant in that space?
Yeah, so of course, when we're talking about the complainant in investigations into sexual harassment, we're wanting to try and have a much more person-centred approach. So what that does is calls us to do is consider our language. So the regulator very much recommends we steer away from using complainant and complaint and instead adopt a more neutral wording, such as a person making a disclosure, person making a report. This is just to address the negative connotations that are often associated with a complaint.
And remember, and we've just taken everyone through in quite, relatively high detail, the fact that there are all these things going on in relation to sexual harassment issues that aren't just one employee being unhappy about the way they were treated. There are safety risks involved. There are breaches of the positive duty involved. There are breaches of the Fair Work Act involved. It's not just a complaint. It's not just a complainant. And it's more of a mindset thing, I think. You really need to think of people who are making these reports as you would if they were making a safety report. You don't necessarily in safety say, oh, well, this person's made a safety complaint. It's more that they've made a report or that they've filled out the various forms. It's not just semantics, but in saying that, no one's going to go to jail for accidentally using the word complainant or accidentally having slipping up in terms of the way they speak about these things if they use complainants. And clearly, I mean, it's on the slide. We're allowing it by having this slide. It's not just semantics. It's important, and you should try and do it. It is a person-centred approach, and you should try and achieve best practice where you can.
And of course, we want to promote a zero tolerance policy with respect to this unlawful conduct. But you'll see that we've got an extra question on the slide there. Is an investigation appropriate and necessary?
Yeah, I think there's probably a lower likelihood in sexual harassment matters that you can make the call from the outset saying we don't need to investigate because this is nothing. There are some workplace issues that arise that you can make a legitimate call to say, well, we're not going to investigate because this is nothing. Sexual harassment, for all the reasons that we've talked about, isn't really like that, and I think you would be running a risk. You would want to be very, very confident that it was nothing. Yeah, I can't see that happening.
It's leading into a good segue about what happens if you ignore, fumble the disclosure. What can go wrong?
Because it is an excellent segue, Alana, because the risk is so high. This is an area this is an issue that if you get wrong as an employer, you are in a world of pain. You can become the example, the poster child of the regulator. They will be looking for the poster child of who is not compliant with the positive duty, because this is the emphasis. This is the movement to hold employers accountable for ensuring that their staff are safe from sexual harassment. Probably even worse than the regulator is the prospect of the media getting involved. If you are an organisation of any notoriety whatsoever, any public interest, to get on the front page with a sexual harassment scandal or story is it's very ugly.
And you can see some of it on the slide right there. Once it's on the web, it's very difficult to get it down.
Correct. And obviously claims, that's not said in any cynical way. It's just the reality. These are things that you do not want to have to deal with, and so there's all kinds of reasons why you put in policies and procedures and risk assessments to avoid sexual harassment happening in your workplace. But where it does, where there are reports made, you want an investigation process, which means it's not going to end up on the front page. The rest of it, unfair dismissals, adverse action claims, workers' comp claims.
And then the impact on your workplace culture, and this can happen before the investigation's even off the ground. If a person is not trained on how to handle disclosures when they're brought to them, if they don't know what to do, don't know how to treat it with sensitivity, confidentiality, don't know the processes established for managing and responding to these complaints, loss of trust.
If they do nothing. Well, I mean, what are you to think as an employer if your employer does nothing in the face of a sexual harassment complaint? Very, very damaging. So, high stakes, high risk, important to get right. Well, how do we get it right? This is sexual harassment investigations arise from reports. It's the same as you would do with any report. You have a preliminary assessment of the report. You plan it. Investigation is 80% planning. What are the issues? How many people involved? Who are the players, e.g. senior management? That is a really tricky and important question to ask in sexual harassment context, because very often, in fact, in almost all cases, sexual harassment has a power dynamic to it. Obviously, one obvious power dynamic is senior management treatment and engagement with lower level employees. There are difficulties and complications in investigating senior management, particularly if you're, in the HR team or you're 3 levels down the chain. Having to investigate a board member or the CEO or the CFO or whatever it is can be problematic. We'll get to that in a later question.
And on that first dot point, though, you'll see we've marked very important, because again, this is triggering that person-centered approach. There's a lot of reasons why we want to take the time to get the views expressed by the worker making the disclosure report. One, we need to know what we're looking into.
Yep.
That will actually inform whether we do investigate or not. But also, that's the opportunity to find out how the person making that disclosure would like to proceed with it. Do they want it informally dealt with? Do they want to go down the formal route? Now, obviously, that preference doesn't dictate how you're going to do it. It might ultimately come to it that an investigation has to happen, it's just too serious, the risks to other workers, et cetera, et cetera. But that person-centered approach requires you to support this person by respecting their dignity and actually letting them have that agency, communicating with them. But we'll come back to that a bit later as well.
We will. I might just pick up on it because it's a good point. You hear a lot about agency in this space, and you're right. The reporter or the person making the disclosure, the complainant in the old world, can't dictate exactly what you do as an organisation or as an investigator. But sometimes, and I'll use an example just to make it obvious, if a complaint is made, a report is made about one person having an interaction with, let's say, a client, where that client said something taken as offensive, relatively medium to low on the scale of seriousness, and the person making the report just said, this happened, I want you to know about it, this person said this unacceptable thing to me, I don't want to work on that client again. If you can just make that move, if they don't want to take it any further, if they just simply say, I don't want to deal with that client again, it's a minor client, I don't have to deal with it, just can you make sure that you don't put me on a call with that person again? That might be enough to satisfy the positive duty. That might be all you can do because they're a client, you obviously can't take disciplinary action against them. Having an idea of what your employee and what the reporter actually wants to get out of the process is so important in this space more than other investigation subject matters, I think.
Then we have that final question.
Yeah, is there a connection to work? Because a lot of people are interested in this when they talk about sexual harassment. They're like, well, is it really connected to work? Yes, there was this thing that happened on between two of our employees, and these bad text messages or this bad comment or whatever happened. But it was on a Saturday night. It was at the pub. It was at the club or whatever. It hasn't got anything to do with work. We can't do anything about it. What do you say to that, Alana?
If you have knowledge in this space, do not ignore it. Do not sit on your hands here, because the positive duty requires you to prevent and respond. So we don't necessarily need to go into, we could, but we won't today, go into all the case law and legislation regarding connection to work. But this is going to what we'll soon talk about, that golden rule. What's going to happen if we don't?
Yeah, the positive duty makes it simple in a way, because the positive duty requires you to take steps to ensure that people aren't sexually harassed. And if an incident outside of work has the potential to affect work, which it almost certainly does, particularly a serious incident outside work, it's going to come into the workplace. You are bound by the positive duty to deal with it, to fix it.
So now we're turning to assessing reports or disclosures. What do you have to say about this, Jules?
Yeah, look, it's a continuation of the previous slide. You're going to need enough information to proceed. That might require you to ask some further questions. We've got a lot of questions about anonymous reporters, which we'll get to shortly. I just think in particularly sexual harassment matters, because the stakes are quite high, you really do need to do a fair bit of work at the front end of an investigation to work out the steps of what you want to do and what you're trying to achieve out of it. This is not a mode or a category of investigations where you essentially, well, we've got the report, let's just start and see let's make it up as we go. It's just a point where you need to make a plan through. But maybe on the next slide, when you are making that plan, when you are assessing the report, when you're thinking about what you can do and what you should do and maybe whether you need to do anything, this is my golden rule. This is what I live by in workplace investigation, but particularly so in sexual harassment investigations. What is it going to look like if you do nothing? And this applies to anything. It applies to the anonymous report. It applies to the employee who says, this happened to me, but I don't want to take it any further. This applies to the extra bit of information that you get during an investigation. Maybe you're investigating one report and you talk to another employee and they raise some other issue that is very concerned. What is it going to look like if you do nothing? In the context of a regulator looking to regulate, in the context of the positive duty, in the context of the Fair Work Commission having a new jurisdiction, in the context of the media being extremely interested in sexual harassment issues, in the context of post-Me Too, it's going to look very bad if you do nothing. Cover-ups, ignorance, too busy, too hard isn't going to cut it, and you can always do something. But we'll talk more about that as we get into the questions. Choosing the investigator. I've got some strong views on these. I'm quite excited.
I won't stop you. Go. Continue.
They just need to know. They need to know what they're doing, and they need to have a solid base of competence, but also obviously not be conflicted out. And so that could be anyone in your organisation. But given how new some of the new laws around the protections in this space are, I don't think you should just assume that people will be able to competently undertake sexual harassment investigations as they would with workplace bullying or misconduct or performance management or any of that kind of stuff. Like it's a relatively specific area, and if you don't have anyone in your organisation who knows it, consider getting an independent person to investigate. As we say in the bottom of the blue box, again, consider the circumstances of the person making the report. I might be, as an investigator, an inappropriate person to investigate a particular complaint because it's made by a particular person or because it's about particular subject matter where the person making the report is not comfortable with me doing it, not because my name's Julian Art or because of who I am or because I know the person, because sometimes it's more important that someone be of a certain age, someone be of a certain gender, someone be a certain background, someone be trained in a certain way. You just got to pick the right person.
And then you can get the other complication if the actual disclosure may concern, say, one of the board of directors or a CEO. That should raise questions about, should we put the HR manager as the investigator, who we usually do, or is this time for us to question maybe an external investigator would be a more appropriate choice here?
Correct.
Think ahead to the interview.
Yeah, correct. And I guess one of the variations of what will it look like if we do nothing is, well, how is this going to look? That's not, again, it's not said in a cynical way. Meaningfully, how is it going to look? How is it going to be perceived by the person that you're interviewed, by the Fair Work Commission, if it ever assesses the investigation process, by the regulator? So don't overthink it, but think about who's going to investigate this thing. Can they and should they?
And then on this slide, here are the key attributes that investigators in all investigations need to be able to have. They need to be able to be impartial. We're not having a cross-examiner enter the room for either the person that was making the disclosure or the respondent. They have to be impartial, have that commitment to a neutral discovery of facts. And that's why I'm saying don't think about a cross-examiner here. Questions to get that discovery of the facts.
You need to, again, we always have to tie this back to sexual harassment investigations. The person investigating sexual harassment claims needs to be of an emotional intelligence level where it can relate, where that person can get a person who's making a report to open up to them about, what could be a very troubling, traumatic experience. Or maybe it's not. Maybe it was just an unacceptable, unwelcome experience, but it wasn't. It didn't have any lasting permanent effects. At the same time as walking to the room with the respondent and having to deal with the respondent who's being accused of sexual harassment, getting what you need out of that person, not so you can cross-examine them, not so you can get a confession out of them, not so that you can stitch them up and make sure that they can't bring an unfair dismissal, but so you can get to the point of investigation, which is to find out what happened. That's all you're trying to do.
And this is going back to what you were saying before, where the investigator needs to be informed. They need to be able to apply that reasonable person test. And Jules, you're very passionate about this point as well.
I'm massively passionate because I think the reasonable person test is quite a specific test. It is a low bar. And I think for most people need to really get into the head of a reasonable person and understand that it's not just, as an investigator, you are not saying, well, I wouldn't do this, or I would be offended by this, or that's not the test. Occasionally I've seen investigators make findings where they say, they don't say it, but you can tell it's implicit. They think, well, what the respondent is alleged to have done isn't that bad, and I've probably done it as well, so I'm going to say it's not sexual harassment. Irrelevant, not the test. It's would a reasonable person, having regard to all the circumstances, anticipate the possibility that someone would be humiliated, offended, and so forth. So really understanding that test is very, very important. Impartiality we've already talked about, but and also appropriateness having regard to the context. Even the most excellent workplace investigator who knows this stuff backwards, who knows the law backwards, might not be appropriate in the scenario just because of who they are. And again, I don't think that's overthinking it. That's just thinking about this in a deliberate way for dealing with what can be a very sensitive scenario.
And now let's give an overview of that process. We've started talking about, do we need to investigate? We've just dealt with who should investigate and going to soon touch on planning, but here's the slide to take a screenshot of so you can keep following along.
Obviously we're not going to go through this slide because it's way too busy, but in a broad sense, it takes you through what an investigation looks like. There's a lot of planning steps, so there's at least 4 planning steps at the start of that. That should give you a clue that before you do anything as an investigator, you should sit down and really break down what you plan to do. The complainant or the reporter or the disclosure or whatever it is in your policy, depending on how current it is always the first port of call, and then we go through to the end. But let's possibly the next, we've talked about planning. Yeah, and I'm not sure we need to overdo this because I think we've probably touched on most of this.
Well, then we'll just go to the first meeting with the person that made the disclosure, the reporter, complainant.
Yeah, so that's the first meeting you would undertake, right?
Yes, and must do, Julian. What is the must do in this meeting? What does everyone listening have to do in that meeting?
So my must do from meeting a reporter or a disclosure or a complainant, and this applies to in every investigation that you would ever do. The thing you need to leave that interview with is a precise scope of what the complaint, what the report actually is. And when I say leave the interview with, often, and it's far better practice to summarise what you think the complaint is, what the disclosure is, what the report is, and then emailing it to that person and get them to confirm in writing, this is what they say happened. The reason why that's so important is the investigation could go off in any number of ways. It could give rise to other things. Other people might make other allegations. There could be counter allegations against the reporter, the disclosure, the complainant. But you need to frame it up at the start so you have the relevant questions that you're going to be answering in the investigation. What does the reporter, the disclosure say happened? And once you've got that, you can ask other witnesses, well, did this happen? You can say to the respondent, did you say these things? Did you do those things? And if you don't get that from the complainant, the reporter, the disclosure, you're starting off on the wrong foot and you're going to become unstuck.
And giving them that chance also to, after the interview's happened, to review a draft statement or to review how you've captured it in writing. It's sending the message to them that they're participating in this process, that they can really make sure and be confident in what they're saying is being listened to, understood, and conveyed. And this is going back to the person-centered approach. We received lots of questions about how can we actually implement this person-centered approach into the investigations. This is another way.
It's an excellent point, Alana. Like it puts a paper trail in writing that you are taking the report seriously and that you're going to do something about it. That will mean a lot. You have to get the tone right. And maybe the last thing we'll say on this slide is the interview needs to be of a tone that's going to achieve the end, which is you're trying to find out what happened. You're trying to get the scope of the complaint or the report or the disclosure. So moderating your tone, it's not an inquisition. It's not a deposition. It is trying to meet a person who's had or claims they have had an unpleasant, unwelcome, and potentially quite serious situation at work, getting them to trust you, getting them to understand that you're going to take their report, their disclosure seriously. You need to moderate your tone because some people are quite good at being people that people can talk to, and other people are more straight up and down and more direct. Think about the tone. Think about the interview style, the location and so forth. Obviously, you need to pick a neutral venue without making reference to the relevant case. Like, obviously, if a particular incident has happened, don't conduct an interview of a complainant or a reporter or a disclosure at the same place where the incident happened. That's just very, very obvious. Confidentiality is critical for this space, probably far more critical than a number of other spaces. Making it clear that you're going to keep things confidential, keeping things on a need-to-know basis. This is the type of investigation that the investigator may well be operating as a bit of a lone wolf for at least some of it, so that not everyone needs to know every stage of the proceedings. And victimisation is a big point here. It is unlawful for anyone to victimise someone who makes a complaint, a report, a disclosure, And I think, in fairness, there's probably a perception by a lot of would-be reporters that if I say something, I'm going to be the one who loses my job, or I'm going to be one that's a scapegoat, or I'm going to be the whistleblower who is marginalised or victimised. You need to manage that really, really carefully because, one, it's unlawful, two, it's unfair, and three, you are actually aiming at a workplace that doesn't have sexual harassment as an issue. So the last thing you want to do is victimise people who are making reports and disclosures.
And before we move on, I'll circle back to the first box there, the person-centred and trauma-informed approach. So talked about person-centred. This is where we're supporting someone's safety and their dignity. The trauma-informed approach is being conscious of the fact we don't want to exacerbate people's harm or injury, trauma in these circumstances. So how do you practically implement that? One, you'd want to ensure the investigator is informed about how to conduct these types of investigations. So whether that's through positive duty training, workplace investigation training, and also with that latter box there with the interview style, location and number, we would want to try and conduct an interview ideally with sufficient time, that we're not rushing a person that's making their report, that we're not saying we only have 30 minutes here and we'll set it up later.
Yeah.
That's the way you can think about the trauma-informed approach, is ensuring you have sufficient time, that you've given them sufficient notice so that they can prepare themselves for the interview as well.
Yeah, in the criminal context, you do hear a lot about the fact that one of the things that you want to do in an investigation, again, criminal context, sexual assault context, you want to have one interview where they can give their account and not have constant interview, where have to say the same thing and revisit the trauma again and again and again. As I said before, for the most part, we're talking about workplace investigations into sexual harassment where the stakes might not be as high, it might be not as serious a conduct. It's still not appropriate to have someone have multiple interviews. We'll talk. Your example is a brilliant one. Let's have half an hour here. If we don't get to the end of it, we'll see if we can catch up on Friday to finish off your complaint. That's not a trauma-informed, person-centred approach. Prioritise, organise, and get it done properly.
And the key caveat I would just say to bring it home on this person-centred and trauma-informed approach, it's not about taking sides. You still have to retain that impartiality. It's not assuming that the person making the disclosure is telling the truth or is 100% correct. It's about just giving that support.
Yeah.
And that it really is about your approach and style there. And I guess an opposite to a person-centred approach would be if your policy was very systems-based. It's like, we're just going to do the interview on this date, this is the next step, and you're just kind of going by the processes and making decisions without considering people
that's
involved.
right. When we talk about the two sides of it, let's click to the next slide. You've also got to engage with the respondent. And I'll just take us through this quickly because we're probably going to run slightly short of time. You need to decide whether you're going to suspend respondents. That's an important question. If there is an ongoing risk to safety, there probably is a good case for suspending a respondent. Also be a bit creative with it. Given Teams, Zoom, online working from home, there are ways that you can separate employees who are dealing with these issues without necessarily putting someone on suspension with pay. Engaging with the respondent, here's the must-do for respondent. If the must-do for reporters was making sure you get exactly what they say happened, the must-do for respondents is whatever you're going to rely on, whatever's relevant, you have to know what the respondent says about that. That's procedural fairness. So if you're going to rely on anything, you have to know what the respondent's side of the story is. That means a letter of allegations is very important. Take your time in it. Take your time with it, make it detailed. And I think on the next slide, we see a letter of allegations. Sometimes people are kind of awkward about allegations of sexual harassment, or maybe they didn't really want to push the reporter or the disclosure or the complainant in that initial interview, so they don't have enough detail about what actually happened. So when they're talking to the respondent, they say something like, well, you've engaged in sexual harassment against staff members. What do you say about that? Completely insufficient. It's not enough information to provide a meaningful response. It doesn't afford procedural fairness. What you need is the dates, the details, what was said. We haven't given an example of the actual words because if we had put it there, it might, probably spend the next 25 minutes talking about whether it's sexual harassment or not. You need to have specifics in the letter of allegations, as you would for any investigation.
And now we turn to the interview of the respondent. What do we do if we're met with the different things on the screen there?
Yeah, so really briefly, this is an area where respondents can genuinely be ignorant. They genuinely did not know that what they were doing was sexual harassment. That's something that you will need to deal with. Again, your job is to find out what happened. It's not necessarily to find out the motivation, although they'll probably give you the motivation. You could just have someone genuinely ignorant who might try and say sorry. The other thing that you can get are very defensive or aggressive, meaning the same thing in this context, respondents. So people appalled that they've been accused of things, people throwing around words like defamation, throwing around phrases like constructive dismissal. You need to hold your nerve as a workplace investigator. You need to have a plan about how you're going to deal with that. If a barrister comes along with the respondent or a lawyer comes along with the respondent, you need to have a plan about how you're going to deal with that volatile situation. Falling back to the basics, you're there to find out what happened. You're there to find fact, and ultimately you want to hear the response from the employee, not from their barrister, their lawyer, or their union rep, or whoever it is. The reason why you have defensive/aggressive respondents is the consequence of all of this is very serious. You've got legacy and reputational issues of people on the other end of these disclosures. That's why confidentiality is so important. These things need to be done extremely professionally and confidentially. So if there is no substantiated allegation, there is at least a chance that the respondent can return to work as usual.
So now we've done all the interviews, we're turning our minds to drafting this investigation report.
Yeah, look, all of these matters are relatively straightforward that you would include in any investigation report. I think if we click to the next slide,
this is going to be the key thing to focus on in sexual harassment investigations.
I just want to make the point that this isn't TB in terms of these aren't criminal matters. There aren't jury holdouts where someone isn't satisfied beyond a reasonable doubt that something occurred. The balance of probabilities is the relevant standard of proof. It means that most of the time you can make a decision as to what happened. You don't need to be certain that it happened. You don't even need to be so sure of it that there's no reasonable doubt. All you need to know is that it was more likely than not that it happened. What's more likely to have occurred? Did they say this or did they not say this? I've put on that slide the likelihood of a they said, and a lot of questions have come in about where it's just a he said, she said. I've gone with the more 2024 version, they said. The reality is that most of these investigations are they said. Most sexual harassment does not occur in front of a crowd. I think that's fair to say. Certainly some does. But often it is a they said. It's not enough to simply say, well, it's a they said. I can't be sad, I can't do anything else unsubstantiated. There is a lot more you can do. You can look at other evidence. You can look at, you can interview witnesses who maybe weren't there but saw the reaction of the witnesses after. You could look at sort of asking people whether whether things like that had ever happened before. You could make some considerations and deductions as to whether you think it's more likely to have happened than not. That's the job.
And on the slide there, of course, they can consider the demeanour of the participants, what you're observing in the interviews. You can form a view about their credibility as well. That's all relevant to this analysis you're doing.
Correct. Put on your detective cap and monocle, put on your judge's wig and actually make the call when you're writing the report and explain why you've made a decision either substantiated or unsubstantiated. You might be wrong. Absolutely, investigation reports can be wrong, but the relevant test that you're applying, the relevant standard that you're applying is more likely than not. It's not beyond a reasonable doubt. So I think we need to be empowered to make a call on these things. And there's been some very highly publicised civil cases in the federal court recently, which goes through that process And there is a good reason why criminal cases often has different results from civil cases, because the standard is different. In reports, Alana, if someone has committed or is found to have committed sexual harassment, are they always dismissed?
Yes. No. Of course. Give him a heart attack. Of course we don't want there to be of course we don't want to just assume that, yes, if something's substantiated, there is one solution and that's always going to be dismissal. Yes, that might ultimately be something the decision maker, who shouldn't be the person conducting the investigation, might ultimately do, but that's not necessarily the final outcome of a substantiated allegation.
Some sexual harassment is so serious that it's just obvious and it's summary termination with extreme prejudice. Others is of a lower level that you wouldn't be able to defend an unfair dismissal. Some organisations take the view that we have a zero tolerance approach to sexual harassment, and therefore if it's ever found, we will terminate. Obviously that's your right as an organisation. There's going to be some risk in a zero tolerance approach if that person brings an unfair dismissal, because maybe you don't have a valid reason, or maybe it wasn't procedurally fair. Just understanding that not every substantiated finding is an instant dismissal. Refer to the spectrum problem here. It's connected to the topic we were just talking about. Because all sexual harassment is on a spectrum, often a report will only be useful if it can make some kind of comment, some kind of finding about whether it's serious sexual harassment warranting dismissal, or less serious, not warranting dismissal. We said a few slides before that only make recommendations if asked for. I think just confirming with whoever has asked you to investigate a particular problem, confirm whether they want you to recommend dismissal or the appropriate sanction can be really helpful, because sometimes receiving a report that just says, yes, sexual harassment occurred, it begs the question, well, what do we do now?
Now we're going to speed run through some questions that we received.
There's some great questions, and some of these have been incorporated into the slide pack from people answering online.
We dealt with this earlier before at the outset. If an allegation's been made against a board member, that should raise questions about who is the appropriate investigator, and maybe it's external. So we'll move on to the next question.
Might just give me one bite of this.
Be quick,
the only thing, if the questioner is actually asking, because it's a board member and they're kind of off-site, and they're not operational stuff, so we don't kind of need to deal with it. Maybe we can just do nothing. It's a colour or it's a metal. What kind of rule are we going with?
The golden rule.
What's it going to look like if you do nothing? It's going to look terrible if a complaint has been made against a board member and you do nothing. That will make the papers. That will make the regulator, and it's in breach of the positive duty. There is no reason to treat it differently apart from picking the right investigator.
Next question. Is it beneficial to have one employee who is responsible for receiving, investigating and actioning sexual misconduct complaints? Should just be one person, Jules?
If you've only got one person who's competent and appropriate to do it, then I think you'd have to do that. It can work. I think, given my comments about how not everyone is appropriate to investigate every type of sexual harassment case, I tend to think that sometimes having a designated person might give rise to problems, that person might not be the right person for a particular report or disclosure. But if that's all you got, if that's okay, what you really need to have is a well-trained, disciplined group of investigators, and your group may be just one, who knows how to deal with this, who knows how to keep it confidential. There's a lot on the plate of an investigator of a sexual harassment complaint. This isn't group work generally, so if that's the case, yes, one person's okay. Specific training. If you're not across the positive duty and what we've spoken about, if you're not across workplace investigations, we can help. I don't think that's a plant question, but yes, we can help with you.
And of course, decision maker should be separate to the investigator. Now, we said we were going to come back to the anonymous complaints. I might just turn to that if I may.
Yeah. How do you manage allegations of sexual harassment where the employee making the disclosure is anonymous, i.e. you don't know who the person is? well, what will it look like if you do nothing?
Golden rule.
You can do something. You can ask around in a discreet, confidential, appropriate way. You might end up with nothing. If an anonymous complaint comes in as a random piece of paper on your desk, you might not be able to do much, but you can do something and at least try and at least keep a record that you tried if anything arises from an anonymous complaint. Where the employee wants to keep their identity secret from the respondent, we talked about what a respondent needs. The respondent needs to have enough detail to respond. Sometimes that's hard to do. Often I would take the approach of explaining why we may need to disclose your identity to the respondent in order to give them to undertake the investigation. That can be a difficult conversation. I think it's one of those things where you should really get advice on. When the employee does not want anyone to know, golden rule, what will it look like if you do nothing? The fact that the employee wants to give that disclosure but doesn't want anything to occur from it, probably not. It's probably not a reason to do nothing. Positive duty requires you to do something. You can be persuasive with the employee to try and get them on board to trust you so that they trust that you're going to take it seriously and that they're going to get some result out of it.
Do we have one more time to squeeze in one more question? Because there is one of when things go wrong during the investigation.
Yes.
How do you redeem, recover and get back? And we've received similar questions along this.
Yeah, there's a range of questions online about this, and this will be the last one. And it's a good way to close. Look, there is always time in investigation. Yes, they're high pressure and you have to be working to resolve investigations quickly. But there's always an additional question to ask. You can always go back to a reporter, you can always go back to a respondent, you can always clarify something, you can always ask for the additional information. My response to this question is take a breath, think about what step you can take to redeem, to recover, to get back on track, and make the step. And know that no investigation is perfect, but usually the answer is to do something rather than just say, well, we'll just ignore that and hope everything's okay. So we have various resources that we can assist you with. Many of the people online will know about our sexual harassment positive duty how-to guide and toolkit. If what we were talking about in terms of positive duty was new to you, I'd be very surprised. But if it is new to you, this is something you absolutely need to get on top of. Contact us because it's a very simple and easy solution. There's more than one toolkit though, isn't there?
We also have the psychosocial hazards toolkit. Again, if you're still catching up in this space or trying to figure out how you start in this space, we have resources there to help you as well.
We exist to make life easier for business, so
that's why we're here.
They're good resources. So please get in touch. There's a whole range of other things we can do for you. Most of them are on the screen. Let's hype the upcoming training courses: positive duty, 4th and 5th of June, work, health and safety, psychosocial hazards, 12th of June. Those courses are brilliant. You learn a lot, even if you know about the subject matter. If you know anything about the subject matter, please get involved. Otherwise, it's been a great pleasure, Alana.
Yes.
Had a great time, and hopefully we'll see everyone soon. Thank you.
Thank you.